chapter of today's presentation is about assessment and collection. All right, here we go. So this is the way that homeowners think about their association. This cartoon, it's the letter that the homeowner is receiving. It says, unless we receive the outstanding balance of your HOA dues within 10 days, we will have no choice but to destroy your credit rating, ruin your reputation, and make you wish you were never born. If you have already sent the 7 cents, please disregard this notice. That is the way that the owners think about us when it comes to assessment collection. But obviously, we've got a much different idea about that.
I did promise somebody to get to one question before we got to the start. Just condo special meeting to vote on a special assessment. Would it need to be in person and proxy versus electronic? Could it happen both?
So a condo board meeting to vote on a special assessment?
Condo meeting, condo special assessment meeting, or condo special meeting to vote on a special assessment.
Well, it just depends. You can have electronic board meetings and you can have electronic membership meetings. It's just going to depend on what your declaration says about who approves a special assessment as to which kind of meeting it's going to be. So you just have to look at your governing documents. Okay, so I'm going to talk about the authority to levy assessments, where that comes from, the types of assessments, late fees and interest, assessment liens, payment plans, the collection process, in general, foreclosures, the federal debt collection and Texas Debt Collection Practices Acts, and how bankruptcy affects the collection process. Yes. So the collection of assessments is primarily governed by your declaration and Chapter 82 and 81 if you're a condominium, and Chapter 209 if you're a subdivision association. The primary difference, and I think I alluded to this earlier, is that the Condominium Act is an enabling statute. That means it actually gives your association certain powers that you may not find in your declaration or your bylaws. Chapter 209 is virtually the opposite. It's a regulatory statute. 209 limits what an association can do, even if they're empowered to do so in their governing documents. So it's important to keep in mind the differences between those two statutes. Now, why do you need to collect assessments? Obviously, this is the lifeblood of a homeowners association. Certainly, there are other ways that you take in income, but they are few and far between. Without your assessments, you can't operate. You have to maintain and repair the common areas and the common elements, and importantly, it's within your fiduciary duty to provide for insurance against casualty losses for the common areas and the common elements. And without assessments, you cannot function. Now, with respect to condos, TUCA, which is Chapter 81 and 82 of the Property Code, establishes your right to collect assessments. So in the unlikely event your declaration for your condominium doesn't mention assessments anywhere, you still have the right to collect them. Of course, it will likely be established by your declaration. In a subdivision association, you have no statutory right to collect assessments, so it better be in your declaration, and you have to follow that, the way that assessments are collected to the letter of the declaration. Now, the types and amounts of assessments will be established in the declaration. The authority of the board to increase the amount of an assessment is generally provided for in the declaration. The board may not exceed the amount or types of assessments authorized by the declaration. That's important. I get a lot of requests, at least several times a month, from boards of directors that need money. They want to impose a special assessment, and quite often we look in the declaration and there's not even the right to do so. So it's important that before you start raising assessments or levying special assessments, that you look to your declaration to make sure you've got the right to do it. Now, in general, there are 3 types of assessments. You've got regular assessments. These are the annual, monthly, quarterly assessments. They're assessed on a regular schedule. They're a uniform amount. They're almost always tied to your budget. You have special assessments. These are assessed on an ad hoc basis. They're generally also a uniform amount, but they are usually to cover budget shortfalls or special projects. And then you have individual assessments. These are assessed also on an ad hoc basis. It's a non-uniform amount, and these are generally assessed against either an individual owner for things like fines or damages, or a subgroup of your total owners because they're responsible for a special area of common responsibility. Late fees and interest are a good way to remind owners that they need to pay their bills. They do, however, have to be authorized by the governing documents. If you're a condominium association, you have the right to charge late fees and interest under TUCA. Under Chapter 204, if you're a subdivision and you're in Galveston, Harris, or Montgomery counties, you can charge late fees and interest. For all other subdivision associations, the only way you can charge late fees or interest is if it is contained in your declaration. So let's talk a little bit about what an assessment lien is. So a lien is a security interest granted over an item of property to secure the payment of the debt or the obligation. So an assessment lien is established in favor of an HOA against each lot or unit to secure the payment of assessments. An assessment lien must be created by statute, that refers to TUCA, or the HOA's declaration if you're a subdivision. Then an HOA may foreclose upon the assessment lien if the assessments aren't paid. In a condo association, the lien is established by TUCA, and it may also be mentioned in the declaration. In a subdivision association, if you've got a lien against the lots in the association, it will be established by the declaration itself. The scope of an assessment lien for a condo is established both by TUCA and the declaration. And under TUCA, a condo assessment lien secures regular and special assessments, dues, fees, and charges, fines, interest, late fees, and collection costs, and any amount that's owed to the condominium association by an owner of a unit. That basically means everything. That's different from a subdivision association. The assessment lien in a subdivision association only secures payment of the specific types of debts enumerated in the declaration. We also talk about perfecting a lien. This is the procedure by which a lien attaches to the property and is then legally enforceable. The priority of a lien is the order in which creditors that have a lien on the same piece of property are going to be paid if there's a foreclosure. In general, in Texas, we have a first in time, first in right statute that just means the earliest lien prevails over later liens. There are some exceptions to that. Now, in a condo association, the assessment lien is established and perfected when the condo declaration is recorded. That's without exception. The lien takes priority over all other liens besides tax liens, liens that were filed prior to the declaration being filed, a first vendor's or deed of trust lien, that's just a purchase money security interest, that's your typical mortgage, or a mechanic's lien, unless it's otherwise provided by the declaration. In a subdivision association, the assessment lien is often perfected by the declaration, but that's not statutorily dictated. So if your declaration says something like the lien against the property is only perfected upon filing of a notice in the deed records, then you haven't perfected your lien until that notice has been filed. So you have to check your declaration. The priority of the assessment lien is determined, again, by the first in time, first in right provisions under common law, but there are exceptions via statute. Tax liens filed after the declaration will supersede the association's lien, and most declarations subordinate their lien to purchase money liens like deed of trust liens. And since the Texas Constitution was amended about 25 years ago to allow for home equity loans, most declarations filed after that period of time allow for the subordination of the association's lien to home equity loans as well. So with respect to subdivision associations, if somebody falls behind on their assessments to the association and you've got at least 15 lots in your community, you are required to offer them a payment plan. Now, this is not required to be offered if the same owner has defaulted on a payment plan within the last 24 months. And it's not required if the owner fails to request it within the period of time required under 209. This needs to be updated to 45 days. You're required to give a notice before you send an owner to collections that they could potentially have to pay additional fees if they don't enter into a payment plan or pay in full within a period of time. That's 45 days from the date of that letter. Then after that letter is sent and time expires, you can send them to collections. You are not required to offer a payment plan more than once every 12 months. And the payment plan that the law requires has to be between 3 and 18 months. Of course, you can offer a payment plan longer than 18 months. The law just requires that you offer one that's at least 3 months. You can't charge monetary penalties like late fees or collection costs to an owner after they've entered into a payment plan with you, but you can charge reasonable administration costs, and you can even include interest. We almost never include interest when we set up payment plans. It's never that much money, and it's almost not worth trying to calculate it and collect it, but it is legal to do so. Now, with condominium associations, there's no requirement that you ever offer a payment plan, but we handle collections for condominiums, and we always offer payment plans. I think it's a good time to kind of talk about the general principles of collecting these dues. While it's vitally important to an association to collect its assessments, you've also got to balance that with the amount that's due. It's usually relatively small compared to the value of the home, which is what you have the right to foreclose upon. So we're balancing the association's innate interest in collecting those fees so you can provide all of these services that people count on the association to provide, maintain the common elements, maintain the drainage facilities that you've agreed to maintain by virtue of your relationship with the developer. And you have to balance that with some compassion for folks that are experiencing various financial difficulties. Maybe they've lost a job, maybe someone's passed away. And so all of those things have to be taken into account, because ultimately we're going to end up in court trying to foreclose, and you've got to convince a judge that we've jumped through all the hoops that the legislature has set for us, and all the extra hoops that the judge is going to want to see you jump through because you're foreclosing on behalf of an HOA. All right, so with respect to subdivision associations, when you receive a payment from an owner, there is a statutorily dictated way for you to apply these payments. The good news is everybody that's here and probably watching is utilizing a management company to handle the accounting for you. They know how to do this, but it's important that you also are aware of the way that payments have to be applied. So first you apply the payment to delinquent assessments, then to any current assessments that are due, then to reasonable attorney's fees or collection costs that are secured by the lien, then to attorney's fees that are not secured by the lien, then to fines, and then to other amounts. The reason that the law requires application in this way is to allow an owner who's savvy enough to kind of game the system. If they pay you all of the delinquent assessments and current assessments that are due and owing, you can no longer foreclose even if they owe the rest of this money. It doesn't mean you have to write off these other charges and fees, but you can't foreclose. You still have a lien. They still have to pay you when they sell the property, but you cannot then foreclose. Now, there is an exception to this payment application rule. If the owner is in default under a payment plan, when they make the payment, you can apply it any way you want, except to fines. Fines are always the very last thing that you can ever apply a payment to. Now, here's the traditional HOA collection process. So the association, or the manager most frequently, sends one or more collection letters to the delinquent owner. Hey, just wanted to remind you, you're 30 days past due, why don't you go ahead and pay us? The management agent will then refer the delinquent account to a collection attorney. The attorney will send one or more collection letters to the owner, reminding them of their obligations and what the repercussions are if they fail to pay. The next step is to record an affidavit of notice of assessment lien. Then the attorney will initiate foreclosure, but usually there's another step in that process. We send out a letter that says, hey, by the way, we filed a lien, you still haven't paid. The next step is foreclosure. Why don't you call us and enter a payment plan so we don't have to do that? Then the delinquent owner's lot or unit is foreclosed on and sold at public auction. That process generally takes about 9 months from start to finish. There is always the opportunity for an owner up until the day of the foreclosure to enter into a payment plan. And we'll talk about it in a minute. Even after the foreclosure, there's a right to redeem the property. It's 90 days in a condo, 180 days in a subdivision, and they can still come forward after the sale has taken place and redeem their property and get the title back. So there's always an opportunity for an owner to pay you what's due in an affordable way. They just have to contact the association and enter into a payment plan. So the number of letters that is required to be sent is dictated by your governing documents and whether or not you're a condo or a subdivision. In a condo association, there are no letters required. Somebody can owe you $1, and the next thing you do is go file a lawsuit down at the courthouse. I'm not suggesting that that is a good idea, but you just have no requirements to try to enter into settlement negotiations, payment plans, or anything else in a condominium. In a subdivision association, you've got several legal obligations. Before you hold an owner liable for attorney's fees or collections costs, the subdivision association has to send legal notice meeting the following requirements. You got to send it by certified mail. You've got to specify each delinquent amount that's owed and the total amount that they need to pay you to become current. And the way that we always satisfy this requirement is we just send a copy of their current ledger that identifies everything they owe and leaves no question about what they need to pay. You've got to give them 45 days to cure the delinquency before you begin charging them for collection actions. And you've got to inform them of their right to a payment plan. That's if you've got 15 or more lots. Attorneys are not required to send collection letters. So these collection letters can be sent by anybody you choose. There is an exception. If you're in a subdivision association and your lien is subject to a junior deed of trust, then the junior deed of trust lien holder has to be given notice by certified mail of what's owed and give them 60 days to cure that before you can move on. What that does is it gives a mortgage holder who might end up getting knocked off at a foreclosure sale the ability to pay you what's owed and preserve their position in the chain of lien holders.
How do you find who the lien holder is?
No search.
Okay.
All right. So here's how you foreclose assessment liens. In Texas, any HOA, condo or subdivision, can use judicial foreclosure to foreclose an assessment lien. You are also allowed to use non-judicial foreclosure in certain instances. If the HOA is expressly authorized by its declaration or by statute, then you can use non-judicial foreclosure. The Texas Uniform Condo Act specifically authorizes foreclosure for condos. So we continue to use non-judicial foreclosure, which just means a lawyer goes down to the courthouse steps, reads off the foreclosure notice, and conducts an auction. We still utilize that for condos. We don't for subdivision associations. And that's because the legislature 6 or 7 years ago, or it's been longer than that now, required homeowners associations that are subdivisions, if they wanted to use non-judicial foreclosure, to go through what they refer to as the expedited foreclosure process. It's a bad name for it because it takes longer than the regular judicial foreclosure process. And it's more expensive. So we just file a lawsuit and foreclose. All right. So the right to foreclose, judicial foreclosure is the right to foreclose established in a judicial proceeding and carried out by a court order. The big difference is instead of a lawyer conducting the foreclosure sale, it's going to be done by a constable or a sheriff. You got to file a lawsuit, obtain a judgment, and then the judge will establish the total amount due to the association, including the specific amount that's secured by the lien, and it will order the assessment lien to be foreclosed on to satisfy the total amount that's awarded. Then the sheriff or constable conducts the auction. The non-judicial foreclosure is a little different. There's no court supervision. It's performed by a trustee appointed by the HOA. It doesn't have to be a lawyer. It just usually is. The trustee then sells the property at the public auction without any hearings. And before a non-judicial foreclosure for subdivisions, as I mentioned, you have to get a court order anyway. So you're filing a lawsuit one way or the other. Judicial foreclosure is simpler. That's why we do it that way. There are some restrictions on an association's ability to foreclose. You've got the homestead exemptions that come into play, but are generally superseded. Somebody's active duty as a military service member comes into play, and of course, fines. You can't foreclose on someone solely for the fines on their property. So assessment liens are not one of the liens that are enumerated in the Texas Constitution that are exceptions to the homestead protections. However, liens that pre-exist the invocation of a homestead preempts the homestead protection. So in 1987, the Supreme Court of Texas held that assessment liens that attach to property prior to invocation of the homestead preempt such homestead protection. And so the general rule is developers file the declaration prior to selling any lots. If they haven't sold you a lot, you can't declare it to be your homestead until you own it. And so that lien comes before the homestead declaration, and that's what gives us the right to foreclose HOA liens. Now, with respect to a condo, the attachment of the lien occurs upon the recording of the declaration of the condominium regime. And in a subdivision, it is controlled by the declaration and is determined by looking at the declaration. Most often, the lien is perfected by the filing of the declaration. However, sometimes the declaration will include additional steps, and those must be followed before you can actually end up foreclosing. Now, when in doubt as to when a subdivision association lien attaches, foreclose judicially. The homestead exemption is an affirmative defense. So if, for instance, your declaration says, you've got to file this declaration and then you have to wear blue shoes to the auction, we're not sure if somebody wore the right blue shoes, then we just judicially foreclose. If the homeowner doesn't raise the affirmative defense that this is my homestead and so you can't foreclose, then by default, the court has determined that there is no homestead protection, and when you foreclose, you're protected by that judgment. So that's the way to handle any doubts. All right. You may not non-judicially foreclose on an active duty military service member during their deployment and up to 9 months after they've returned from active duty. This applies to property purchased before their active duty commenced. So if for some reason they're on active duty and they buy the property while they're on active duty, the law says, well, hey, if you were able to buy the property while you were on active duty, you can probably pay the assessments. You can still judicially foreclose, but we almost never do this. You have to have an ad litem appointed. Judges absolutely hate it. I've never found one that thought this was a really neat idea. And so the cost is just kind of exorbitant, and they're gonna make the HOA pay the costs for the ad litem. So when you find out that somebody is an active duty military service member, we go out of our way to try to enter into a payment plan with those folks. And just to make it clear, if you knowingly violate the protections under the Service Member Civil Relief Act, you can face a $4,000 fine, 1 year in jail, or both. So we generally try to avoid that. And oh, by the way, that would be for the lawyer who actually completes the foreclosure. No, none of you guys are going to jail. That would just be the lawyer doing the foreclosure that would be subject to those punishments. With respect to fines, a condo association may not foreclose if the delinquent amount consists solely of fines. A subdivision association has additional restrictions. So you can't foreclose if the delinquent amount consists solely of fines, attorney's fees associated with fines, and then there's a couple of other exceptions found in the property code. If somebody asks you to make them copies and you've got an enforceable copy policy and you make them the copies and then they don't pay it to you, they owe you the money and you have a lien for those amounts. Can't imagine that amount would ever be that much, but if they don't pay it, you can't foreclose. Additionally, if they ask for a recount of an annual meeting vote or something like that, and then you do the recount without them paying you, that you have a lien for that amount as well, can't foreclose on it. Those are the exceptions. Now, after a foreclosure, the former owner of foreclosed property may get the lottery unit back within 90 days of foreclosure for a condo and 180 days if it's a subdivision. The purchaser at the auction is permitted to lease the lot or the unit during that redemption period, but you can't sell it. And that applies to an HOA or a condo association and any other purchaser that purchases at the auction. So there's also the Fair Debt Collection Practices Act, both in the Texas statutes and federal. And this applies to the collection of delinquent assessments. And collecting delinquent assessments does fall under the definition of debt collection. Debt collection is regulated by these statutes, and both of the act's requirements have to be followed. The federal one's a lot more specific, but they do both apply. The Federal Debt Collection Practices Act does not apply to a creditor attempting to collect a debt on its own behalf. It only applies to third-party collectors. So it applies when you have a collection agent or an attorney collecting a debt on your behalf. If you were doing it yourself, you aren't considered a debt collector. Management companies are not considered debt collectors. So there's certain things they're able to do that attorneys aren't able to do. Instead, management companies are generally considered debt servicers since they began servicing the account prior to it becoming delinquent. That's really the exception. The Texas Debt Collection Practices Act does apply to creditors and anybody collecting a debt. So while the federal act may not apply to management companies or the board of directors itself, the Texas Debt Collection Practices Act does. And it's the #1 reason why you probably shouldn't be knocking on people's doors and asking them to pay bills or getting personally involved in the collection process. There's a lot of ways to screw that up. Now, the Texas Debt Collection Practices Act prohibits debt collectors from threatening or coercing people to paying bills, oppressing, harassing, or abusing debtors, using unfair or unconscionable means, and using fraudulent, deceptive, or misleading representations. And here's how you can violate the act. If you represent that the amount owed by the owner can be increased by attorney's fees, service fees, interest, late charges, or other charges, if those charges aren't expressly authorized in the declaration. So you can very easily say, hey, if you don't pay this bill, we're going to impose, a number of charges against you. If one of those charges in that list is not actually authorized by your declaration, you've technically violated the law. If you collect or attempt to collect interest or late charges that aren't authorized by statute or declaration, if you misrepresent the character, extent, or the amount of the debt, or if you represent or threaten to represent to anyone other than the owner that the owner is willingly refusing to pay a non-disputed debt. When this comes up mostly is when somebody's trying to sell the property, the realtor, the buyer calls you, asks you about this balance. If you're not providing them with perfectly accurate information, you can be in violation. That's one of the #1 reasons why you should most likely never talk about a delinquent owner's account with anybody other than the delinquent owner, even if it's a spouse not on the deed, even if it's somebody that is speaking on behalf of the owner, as long as it's, unless it's their lawyer, I would generally refuse to speak about delinquent accounts with anybody other than the owner. All right, bankruptcy can also affect the collection process. There's 2 primary chapters of the bankruptcy code that will apply in almost every situation to a homeowner bankruptcy. That's Chapter 7. That's the one where all your debts are legally discharged. The homeowner's no longer going to owe any debts. And then you've got Chapter 13, where there's a reorganization. It's usually a 5-year payment plan, and the delinquent assessments will likely get paid over a 5-year plan to you. The automatic stay is basically protections against collection actions while the debtor is under the protection of the bankruptcy court. It starts the instant that the bankruptcy petition is filed. No new collection actions can be taken, and no prior collection actions can be continued while the bankruptcy is pending. And there are severe penalties for violating the automatic stay. So we always make sure we don't do that. Now, there is a very big difference between pre-petition and post-petition debt. Basically, what happens is when the petition for bankruptcy gets filed, there's a line in the sand, and all amounts that were due by the homeowner prior to the petition being filed, that's the pre-petition debt. These are the debts that are going to be discharged in bankruptcy. Now, the personal liability for homeowners association dues can be discharged in bankruptcy, but that doesn't mean that you're out of luck collecting it. The lien that exists against the property itself will continue to exist after the bankruptcy. That's why we are very, very careful to keep a separate account for pre-petition and post-petition debt. While the pre-petition debt is stayed, you can't do anything about it. You can't collect it while the debtor is in bankruptcy. You can do whatever you want with respect to the post-petition debt. Now, if you want to go and foreclose for post-petition debt, you do need to go to the bankruptcy court and ask for permission to lift the stay. We do that very, very rarely, and it's only when the balance is very significant and we're concerned that the house might be upside down. With respect to post-petition debt, that's the assessments and other amounts that are levied after the petition is filed, and these are still due and payable. So you continue to send a statement to the owner for those amounts, and they're supposed to pay you. If they don't, there is a pretty simple solution. You call their bankruptcy lawyer, because their bankruptcy lawyer is going to tell them, whatever you do, pay these current bills, so the bankruptcy court doesn't find out that you're not keeping up with your current debt. With respect to discharge of debt owed and payment of claims, the pre-petition debts will only be released with respect to the debtor's personal liability. So it's not the lien that's going to be released. If the owner continues to own the property, both the pre and post-petition debt are still secured by the assessment lien, and the secured claims must be paid before unsecured claims. Now, here are some best practices. Aggressive collection practices increase success. Aggressive meaning start early and move through the process with all deliberate speed. That doesn't mean be a jerk or take actions that aren't reasonably supported by the balances. That's why we always encourage an incremental approach. The first letter that's required by law says, hey, all you've got to do is contact us. You're entitled to a payment plan. Call us in 45 days and either pay your bill in full or enter into a payment plan, and it's going to cost you nothing. If that's ignored, then you've got to immediately move to the next step. It's that sense of urgency that's going to finally get somebody's attention. We have a whole team of paralegals in my office that are just constantly sending out these collection letters and taking in calls from owners saying, I want to enter into a payment plan. The whole point of the collection process should be to get somebody's attention and have them contact you and enter into a payment plan. People just have different thicknesses of skin as to what it takes to get their attention. A lot of us in this room probably get that first letter and go, oh my goodness, I must have missed something in the mail. I need to pay my bill. A lot of other people have to get 4, 5, 6, or 7 of those letters, a lien filed, and a lawsuit filed before they pick up the phone and say, oh, I guess I have to pay this bill. So we'll deal with any variation within there, but we incrementally increase the level of pressure, the cost of the collection step, and the severity of the requested relief in a very reasonable way, such that when we do end up in court, we say, Judge, we've got $3,500 in attorney's fees that we want this owner to pay. We can explain why it was an incremental process and how we got to that point. Always offer payment plans, but you've got to be realistic. When somebody owes you $5,000 and then they come to us and say, and I'll pay you $25 a month. Like I said, I'm not that great at math. 144 hours, I think, is 6 days. If somebody wants to pay $25 a month and they owe you $5,000, it's going to take many years for them to pay off that balance. In my experience, a 6-month payment plan is a nice, reasonable amount of time for somebody to comply with. Once you get over about 12 months, you're just asking people to default on that payment plan and you're setting them up for failure. Of course, there's exceptions to the rule. If the board has been lax about enforcing collections over the last 4 or 5 years, you might end up with a bunch of people with $5,000 and $10,000 balances, and you're going to have to be reasonable. It may take 2 or 3 years to get that paid off for some people, but you've got to be realistic. You've got to balance the needs of the association with the financial wherewithal of the owner to come up with something that works for everybody. Subdivision associations should always judicially foreclose. If you're doing anything other than judicially foreclosing, if you're filing small claims lawsuits, if you have been convinced that the expedited foreclosure process is a good idea, abandon those efforts and stick to judicial foreclosure. It's the safest, most efficient, and quite frankly, the cheapest way to collect your assessments. Adopt a collection policy. Treat each owner exactly the same when it comes to delinquencies. Have a collection policy that moves through the steps in a reasonable and timely fashion, and then delegate that to your management company and your attorney so that it's handled in a smooth, organized fashion. Everybody's treated the same. Nobody can argue that they've been discriminated against or that you're practicing selective enforcement. And that's all I've got on assessment collection.